Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Good afternoon, everybody. I was about to say good morning, but I guess it's morning somewhere, right? So 1 o'clock Eastern. So if you're in the Midwest or California, it's still morning for you. Welcome, everybody, and thank you for joining us for another FIA Group podcast. I'm here with Cindy from our Kentucky office. Cindy, you want to introduce yourself?
Hi, I'm Cindy Merrell. I've been with FIA Group for almost a year and a half now, and I am out of the Kentucky office. And here in Kentucky, it is a gorgeous sunny day, and I'm really excited to talk about all the things that you're going to teach us today.
Oh, come on. I'm not going to teach anything. But for anyone that doesn't know, I'm Chris Aguiar. I'm furniture at the FIA Group these days. Granted, I'm furniture in our new building, but I've been here almost 17 years. And if you had told me I was going to be doing subrogation for 17 years before I started, I would have told you you were insane. But here we are, 17 years later, and here I am. And Cindy, I noticed, so all but one of the podcasts I've done has been with you. I think we should start to jazz this up a little bit. I think the podcast should be named the CNC Subrogation Factory. What do you think about that?
Oh, I like it. It only produces and manufactures quality work.
A little homage to the music group from the 90s. No, I just think it works. Patrick, our producer, I don't know if you can grease some skids on that. I doubt anyone else is taking the reins and naming their podcast and taking it on the road, if you will. But I feel like I want to be the trailblazer on this issue. But seriously, I think I've done 5 of these podcasts, and 4 of them have been with Cindy. I won't say who the first one was with, but in any event, today I kind of want to talk about something that I think gets lost a lot in the subrogation arena. Whenever we're on the phone with plans, they're worried about, and we're talking about reductions, they're worried about setting precedents and making sure that the plan participants understand their obligations. But it really strikes me how often the plans themselves don't understand their obligations, and even their advisors sometimes don't understand their obligations. They're so stuck on, we need every penny back. My broker told me that under ERISA, I'm entitled to 100%. My language is incredible. Chris, you wrote it. You guys wrote it. What do you mean you can't enforce 100%? And they're stuck on one of the 2 most important duties of a plan, and that is strict enforcement of the plan terms as written. And if you focus on that duty alone, you could talk yourself into doing really, really, really crazy things in subrogation cases. Because here's the reality, ladies and gentlemen. As lawyers, we put 2 hats on, right? On one hand, I look at language in a case or in a document or whatever the case may be, and I try to look at exactly what the language says. But then there's a whole other part of it, which is sometimes I have to make arguments that force me to take the language, work with it, try to draw parallels, and use that construct that the language creates to build an argument for a counter. And here's the point, is that if you were to try to enforce a planned subrogation language strictly, you could really talk yourself into doing some really, really, really crazy things. Something like 80% of subrogation cases actually fall under $20,000 to $25,000. And in those cases, sure, you can recover 100% very often. In fact, we do it at a 95% clip. But the alternative to that is that there is a ton of leverage on the other side to force your hand. What do I mean by that? The law literally says you have to sue if you want to protect your interests, and the participant won't hand over the money. I just had a case last week where the plan asked someone on my team, can I sue the lawyer for an ethical breach? And the answer is no. Montanil, the most important subrogation case arguably of all time, literally says, plans, we are not going to let you sit on your hands. You must file suits if you have to protect your interests. Now, what does that mean? In most cases, that means it makes 0 sense to enforce your rights to 100%. I mentioned 20 to 25,000. What about 100,000? What about 200,000? And you might be thinking that's a crap ton of money, Chris. Why wouldn't I want to enforce my rights to 100%? Because you have a second duty under ERISA. And that second duty is one of prudence. You are supposed to be prudent with plan assets. And most auto accidents have less than $100,000 available in insurance money. And most people don't have the assets to go after. Once their insurance policy is exhausted, that's it. You're done. You ain't going to get any more blood out of that stone. And what I'm here to remind people is that that second duty is more important than the first. Because if you don't prudently manage your plan assets, that might be a breach of fiduciary duty. In fact, I would tell you it is a breach of fiduciary duty. The law literally says, there is case law I can point you to right now. The Fifth Circuit is the most important one. And the court literally lays it out for us. The court will objectively assess whether that fiduciary, when in that case, so on a case-by-case basis, utilize proper methods to investigate, evaluate, and structure. The language here is used in terms of investments because it's the most prominent use of ERISA. Acted in a manner as would others familiar with such matters and exercised independent judgment when making decisions. The test of prudence is one of conduct, not a test of the result of performance. The focus is how the fiduciary acted in his selection or decision-making, and not whether there was success or failure. So it's not as simple as we have a right to 100%. Sometimes if you're going to spend more than what the case is worth, that causes a loss to the plan. The ends don't justify the means. And even though there's not a ton of case law on this issue in the subrogation context, it's important to remember that there are two equal and opposite competing duties. And that is enforce the terms of the plan, but also be cognizant that sometimes enforcement of the plan just doesn't make financial sense. And that in itself could amount to a breach of fiduciary duty. And so we often in our world try to make things black and white and try to make things simple. They're just not simple. It's complicated. And, having hard and fast rules, I would say the courts would argue it's not prudent.
It's a balancing act, that's for sure. I find that whenever we're talking to plans, we try to express how that there's a balancing act there. We have to balance those two competing, and they're not always competing, but at times it can be competing interests. And that's why it's important that we do look at it on a case-by-case basis. And that's why we do have to consider sometimes that although we might not like it as a plan, no one wants to give away money, but sometimes it is appropriate as part of their duties.
I would take it a step further, Cindy. It's not only appropriate, it's necessary. Again, these plans get caught in balance sheets, right? The profit loss, if you will. But the reality is that if the act is going to cause you to lose in any sort of unbiased, reasonable world, that should indicate that you don't want to act because losing is not in your best interests. And the law supports that. I mean, let's not even get started on the stop loss thing. But yeah, it's so true. It's a balancing act. And then there are all the the murkier reasons for reduction, media attention. So do you remember the Walmart case?
Right, the Walmart versus Shank case. That was a very interesting case. And so for the listeners who might not be familiar with that case, Walmart, although they had the upper hand, they had the strong language, they had everything, they were not willing to reduce in, I think it was an auto wreck. And what ultimately happened is, although they won in the courts, they had a huge backlash when the public found out about the case. I think it got picked up by a lot of news and media outlets, and there was a lot of backlash against Walmart for their subrogation and their position in that case.
I actually did a presentation about that case. This was back in 2008 or whatever, when I first started talking and asked. I kind of went through all of that media stuff. I mean, Shank's husband went to YouTube and basically petitioned the public to boycott Walmart. Now, is every plan Walmart? No. In some business to business situations, is the engineering company that hires, contractor for something, are they going to care about the media backlash? Yeah, maybe not. Although in today's culture, society, got cancel culture, who knows? But obviously Walmart is an extremely public-facing, consumer-driven retailer. Any person hears the story could be like, whoa, Walmart took this money from this lady, I'm not shopping there anymore. And so it ended up being a huge deal. And to your point, I have lawyers, and you've probably experienced this too, I have lawyers that throw Walmart in my face, and they're like, well, what about Walmart v. Shank? I'm like, the rule of law is in my favor. They won at the trial level, at the Fourth Circuit, and then the Supreme Court denied writ. They were like, we're not doing this again. Like, we've already made this decision. The rule of law that comes out of that legal process is in the plan's favor. But Walmart, even though there was money, I think there was still $500,000, right, in the trust when they sued. And Walmart's lien was like north of $1 million or something like that. Walmart ended up backing out. They were like, whoa. We understand that, and sometimes we have to be more cognizant of the big picture. So Walmart could have, taken Shank to the bank, if you will, and they opted not to. Like, again, not every plan is Walmart, but plans do have to be cognizant that there is more than just the dollars and cents of the situation. I'm not saying plans have to consider those things all the time. I don't think Walmart would have had a fiduciary problem in that case had they pushed, because the plan doesn't necessarily have to care about the business, if you will. The fact of the matter is they could have won that case and there would have been no fiduciary backlash. But obviously the backlash to the company itself was so significant that they were like, let's back off. And so the point is, regardless of what kind of plans have understood to be the case, there's a lot of compelling reasons to reduce. And then I would argue that the law itself sometimes requires it. Where is the kick? There is no kick. There is no lever. It's case by case. It's gray, which is kind of why we exist, right? Right, Cindy, we get hired to operate in shades of gray.
That's when our experience and expertise come into play, because thankfully we do this every day.
And that's why it's unbelievably important to be able to do two things. And that's find the cases, because you can't find what you can't see, right? If you're not looking for those cases, which again, 85% of the cases are worth $20,000, $25,000 or less, and you can recover a significant portion of that money, which death by 1,000 paper cuts, right? You make enough 100% recoveries on $1,000 cases, and now you've got yourself $100,000. But secondarily, having someone with the skill and expertise to negotiate those cases, right? Because maybe I can't get you 100, but if I can negotiate you from 50 to 80, now you're complying with your fiduciary obligations, you're being prudent because you're avoiding the cost of the lawsuit, and you're getting help to maximize that output. And so there's so many factors. It can be disheartening to get on the phone with clients sometimes that are just dug in. And I'm like, you're about to cost yourself thousands and thousands of dollars. Because even if you win, there's a great movie. Oh, it's White Men Can't Jump. Sometimes when you win, you really lose. The famous Rosie Perez quote in that movie. It's, sometimes when you win, you really lose. And a lot of times in these ERISA cases, nobody wins, because it's just a discovery battle. A discovery gets expensive, and you get to the end of the discovery, the participant didn't find any smoking gun that they could utilize, and now we're $50,000 into the case, and we might be settling because it doesn't make sense to continue to spend money to go through the litigation. It's such a interesting dynamic when I'm on the phone with these plans that are just dug in. I think this is my new crusade.
Well, I think that there is value in the present dollar, and that the plans can take that money. They can do what they need to do with that money to grow. And when there's such a delay, and I have not really found that in the cases of when they do litigate that there is any substantial gain. And so they're just losing money when, if we would have been able to try to resolve it pre-litigation, typically the plans, I would say 99.99% of the time, the plans end up ahead, even if they have to take a small haircut on the front end. And I also think it's important that we also talk about, it's not only, we have a lot of plans to consider. It's not just your best employee that if they take a significant reduction on that plan and then they don't, it's a case by case. We have to always look. It's not about the person or the individual that was injured. We are looking at the circumstances of their loss. So that's what we're talking about specifically, what coverages are available. And we're also talking about what the plan has paid, just to make sure that's clear for everyone.
Yeah, I agree. I was on a webinar last week and we were talking about some of this stuff, and this came up, and I just had that moment where I was like, nobody talks about the prudent man standard side of this, the duty of prudence enough. I feel like I'm always talking about strict conformity with the terms, but no one's ever talking about this part. And so I'm going to start to get annoying, I think, of the fiduciary duties under ERISA, because I think it's such a forgotten world. And the interesting thing is there's not a ton of case law on the benefit plan context on this. And why is that, right? Everything we just talked about creates the reality that it doesn't make sense to push. So we don't get a lot of cases. There's not a lot of active litigation on this exact issue. Did the plan do what it's supposed to do under ERISA fiduciary? I am aware of one case, I'm forgetting it sort of right now, where, and I haven't read it in a while, but the claim was brought that it was a breach of fiduciary duty where the plan overstated its reimbursement rights as compared to the plan language. So it's just so important to understand exactly what does the language say, what exactly does it allow you to do, and then once you've figured out that construct, once you've figured out the baseline of what the plan's rights are, okay, but now what are the circumstances that are impacting the issue, and does it make sense to charge, or does it make sense to sit back and go, all right, let's work out a number that everyone can live with so that we don't get caught in expensive litigation where lawyers make the money and not the plans, right?
Yes. And I think that that's something that I'm happy to always answer any questions, and I know you are as well, from any of the plans, because that's what we're here for and that's what we enjoy doing.
Yeah, for sure. That's all I got for today. I just wanted to, like I said, remind all our listeners. I mean, we must be good in the ratings, Cindy. They keep bringing us back together, so we must be crushing it on the airwaves. I'll have to go get our numbers and ratings so I can start throwing that around in people's faces. But yeah, I mean, that's all I got. Plans, remember, that not to make light of it, there is a little bit of a game that's played, and Cindy and I are colleagues that we're pretty good at the game, chess masters, if you will. Always remember that we're looking out for your best interests, and sometimes that means talking you off ledges and not talking you onto them. Thank you, everyone, for your time. Cindy and Chris, the CNC Subrogation Factory, book it. We're out. I got to entertain myself somehow, everybody. Thank you so much for your time, and I hope this was helpful, and we'll see you next time.